no viable claims against Carlisle, Your Honor, we think that this is just an unnecessary addition, that Ms. Sims' testimony will not be probative of anything in this trial that cannot be already garnered from the documents.
Response?
Your Honor, I submitted an opposition there, and Ms. Sims is aware. She even sent emails, which I made it exhibits in my opposition. So she has firsthand knowledge. Your Honor, yes, you did grant them the 91 dismissal, but you did not sever them from the case September the 4th. So that's why Ms. Sims needs to appear and testify.
Mr. Yates?
I don't really have an opinion one way or the other. I mean, certainly there are no claims pending against Carlisle Title. If she thinks she needs her to be able to prove up the emails that were sent, I'm not going to object to those emails. And I don't think there's any dispute that Carlisle Title, as well as my client, was made aware of the fact that there may be a valid written will. And I also don't think there's any dispute about the fact that it was after the closing that had taken place. So I'm not sure what additional information she would be able to add as a witness.
Why don't we do this? Let's just kind of see how the testimony goes. I agree that the Duke Estakum was late. You have to give 30 days notice for that. But as to the testimony, why don't we wait and see kind of what else comes out? So, Mr. Pearman, are you there?
Yes, Your Honor.
What would be the best way? I don't want to keep you kind of on the line, but there is a possibility we may need your client to testify. So,
together. So,
what did you say, Mr. Pearman?
Everyone's excited about that.
I was getting some interference there, Your Honor. I'm not sure what that was, or if someone else was not muted.
Kaneda, who is that? Should they even be in here?
She's the witness, Your Honor.
Okay, she's the one who's providing the interference.
Yeah.
So,
and so, Your Honor, I'm glad to be on kind of standby, as long as I mean, obviously, Ms. Sims will need a certain amount of time to deal with whatever conflicts she has, or frankly, Your Honor, I mean, again, we think there's a relevance objection to the extent that she is well, actually, scratch that, Your Honor. I'm willing to be on standby, and I can make Ms. Sims aware and alerted that she's on standby.
Mr. Pearman, what is your who has your cell phone number? Does Ms. Hunter have your cell phone, or Mr. Yates?
I believe Mr. Yates has my office and my cell number. I will give that. I'm glad to email Mr. Yates and Ms. Hunter with that information right now.
Yeah, why don't you email them that, and then if at some point during the course of the trial we determine we need this testimony, we'll email you, and you can get just make sure your client is available. Excellent.
And again, I'd request a certain amount of notice, but probably an hour's notice if that is determined that there is a necessity for Ms. Sims to testify.
Thank you, Mr. Pearman.
All right. Thank you, Your Honor.
All right, let's go and start with opening statements. Mr. Yates, you may proceed. Each side. Ms. Courtney, why don't you go ahead and keep time? Each side has 10 minutes.
Got it.
Are you ready, Ms. Courtney?
Let me pull up a timer. 1 second.
And give them a 1 minute warning.
Okay. Okay, I'm ready.
Mr. Yates, you may proceed.
And I don't think I'm going to use the full 10 minutes. This case, as I mentioned the other day, and has been discussed in front of you on several occasions through motions for summary judgment, motions to dismiss. Basically, this involves a piece of property that my client purchased from Kenneth Washington. It's undisputed that Kenneth Washington was the only child of Ollie Mae Allen. Approximately a year and a half after her death is whenever this sale took place. At that time, there was no probate application. There was no determination of heirship or anything that had been initiated or commenced in the probate courts. The title company requested an affidavit of heirship to confirm the fact that there was no will and that the only heirs to Ollie Mae Allen was her only son. She wasn't married, didn't have any other children, and there's no dispute that that is correct. There is a dispute about whether or not there's a valid will. However, at the time of closing, my client had no knowledge that there was a will. Mr. Washington may have had knowledge of that. It certainly wasn't disclosed to the title company. It wasn't disclosed to my client. And so he proceeded to closing. That affidavit of heirship was sworn to under oath, under penalty of perjury that's specifically laid out in that affidavit of heirship, which isn't required. But that was the extra precaution that the title company took and required in order to close it based on an affidavit of heirship. It was sworn to by two disinterested witnesses, namely people that didn't have any rights, didn't have any claims against the estate. And so the title company relied on that affidavit of heirship in ensuring the transaction on behalf of my client, Mr. Barton. That transaction closed. My client, as the testimony and evidence will show, paid good value for that property. And he then rehabbed that property, put approximately $40,000 into rehabbing that property, and then subsequently resold it and made a small profit, not unlike he would anticipate making in any other transaction that he does. And so we believe that he is in fact a bona fide purchaser and that he purchased this property for good value without notice of any other claims or rights that anyone else may have in that property. Subsequent to the closing, after it had closed, after it had funded, after all the documents had been signed, after checks had been issued to the seller, my client and the title company were made aware of the fact that there may be a valid will. And subsequently, an affidavit of heirship was filed by Robin Hunter in the deed records, claiming that there were other heirs, which I think is a misnomer. The only heir at law under the laws of descent and distribution were, in fact, Mr. Washington and not the other named beneficiaries under the potential will or the legatees under the will, which is indicated by the affidavit of heirship that was filed by Ms. Hunter. That affidavit of heirship does, in fact, create a cloud on the title, and that's why we have filed a suit to quiet title and to have that document declared null and void to remove the cloud. We've also filed the declaratory judgment action asking that this court declare that my client qualifies as a bona fide purchaser and to uphold the sale of the property to my client. Subsequently, even after the affidavit of heirship, there was an application to probate a will that was filed 2 or 3 months after the closing. To date, that will has not been admitted to probate. To date, Robin Hunter is not the personal representative of the estate. In order to be that person, number one, the court has to sign an order that appoints her as the independent executor, independent administrator, whatever the court would see fit based on that potential.
The court being, you mean the probate court?
That's correct.
Right, that would not be my court.
That's correct. And that application is still pending, and it's been pending since August of 2020, I believe. So nothing has happened on that. So the court hasn't declared that there's a valid will, hasn't declared that there's not a valid will, but certainly has not appointed anybody to be the representative of the estate or vested anybody with the authority to pursue claims on behalf of the estate. That could be done a number of ways. It could be done if that probate was complete. When I say complete, if that will had been decided to be valid, there could have been a temporary administration to appoint Ms. Hunter or some other party to be the representative of the estate for the purposes of being able to pursue these claims. I think our claim is right and is valid against Ms. Hunter because she's the one that did in fact file that affidavit of heirship. And so whether she's the representative or not doesn't affect our ability to bring that claim into quiet title and to establish that my client is a bona fide purchaser. But I do think that there are issues with her being able to bring claims on behalf of the estate. And, at the end of the day, again, I think clearly it's going to be undisputed that my client had no knowledge of the existence of a will, whether it's valid or not, at the time of closing, and that he did pay good value without knowledge. And so we believe that that affidavit of heirship should be declared null and void to clear the title to the property, and that my client should be confirmed to be a bona fide purchaser of that property. And that's the relief that we're asking for here today, Your Honor.
Ms. Hunter?
Okay. Good morning, Your Honor.
Good morning.
May it please the court, counsel. Deception was used to sell my aunt's house. Not once, but twice. I'm Robin Hunter. Growing up, I always had this aunt. Her name was Ollie Mae Allen. I spent plenty of nights at my aunt's house. She was a nurse, and all her patients loved her. She inspired me to become a nurse. At one point, we even worked together at Golden Acres, Dallas home for the Jewish age. As I assisted her when she got up in age, we sat on my porch one day with a cold glass of tea, sweet tea, because that's what she did, made tea. She began to talk to me about her will and what she wanted. She made me responsible and named me as executor. My aunt Ollie Mae left this world on October the 6th, 2018. She only had one thing, and that was her home. She was swindled. This home was swindled away from her. The facts is that, yes, her son attempted to sell this house using an affidavit of heirship by fraudulent stating that she didn't have a will. She didn't have unpaid bills. The day after signing this fraudulent, the day after signing closing documents, I contacted the buyer. 2 days later, the buyer emailed me saying that the sale was canceled. So I figured that he get it. It's a will in place. All this was explained. The buyer, the title company, they all had time to stop this. Yes, did they give Kenneth and Connie checks? Yes. And they cashed them the same night at a check cashing place for an outrageous amount of $1,500. But the pursuit should have been with Kenneth and Connie, because even though the title company and the buyer signed the documents the night before they were made aware, they still had a chance to stop this. Probating a will, you have up to 4 years. I have up to 4 years. Her death happened in October 2018. So yes, have I attempted to probate her will? Yes. But the only thing she had in the will is a house, nothing there to probate. And that house has been taken away fraudulently. And that's what this is about. Now, I will offer documents as evidence to the court to prove the true facts. Yes, I filed an affidavit of facts against the affidavit of heirship, because there were descendants that where the will said that they should have ownership of the home and the proceeds should be divided. A will is valid as long as it has 2 signatures. And so Ollie Allen has a valid written will. Just because it has not been probated, that does not make it invalid. Did the client, the plaintiff, was he a bona fide purchaser? No, he was not. In fact, he fraudulently sold the house again, knowing that we were in these proceedings. He sold the house April 2021, and these proceedings started December 2020. So he's not a bona fide purchaser for good money. In this day and age, if someone offers to sell your house for $40,000, you probably should think twice, because you should say to yourself, this can't be that good of a deal. I don't know anywhere in Dallas County, I don't know anywhere in the state of Texas where you can purchase a house for $40,000.
Oh, you were here?
I'm sorry, say it.
Somebody's not
Okay.
muted. I'll go ahead and mute them. Anything else?
Ollie
Mr.
Mae
Cooper?
Allen died June 6, 2018 with a valid written will. An affidavit of heirship was notarized on May 30th of 2020. It was recorded in Dallas County records on June 12th of 2020. B&A Barton purchased this real property June 12th of 2020. A warranty deed with vendor's lien was recorded in Dallas County records on June 12th, 2020. How can you purchase a house but turn around and give the seller a vendor's lien on a house that did not belong to him? Ollie Mae Allen had a clear deed and was the owner on record in Dallas County for 1243 Whitaker Avenue. Thank you, Your Honor.
Okay. Do we want to go ahead and pre-admit any exhibits? Mr. Yates, do you have any exhibits you're going to be offering today so we can kind of move this along?
I do. I've provided those to Ms. Hunter. We haven't had a chance to discuss if she's got any objections to them. And I believe that your court coordinator forwarded the PDFs to your court clerk. So I'm not sure if she has those.
I have them. Yeah. So those are exhibits
1 through 12.
Any objection to exhibits 1 through 12, Ms. Yates? I'm sorry, not Ms. Yates, Ms. Hunter.
No, Your Honor.
All right. Plaintiff's exhibits 1 through 12 are admitted. Has the defendant submitted any exhibits?
Yes, sir, Your Honor. I have submitted exhibits. I was able to give them to Mr. Yates on Tuesday. I also provided your court reporter with them in its exhibits A through Y.
Have you seen those, Mr. Yates?
I have, Your Honor. I'm not going to object to any of those either.
All right. Defendant's exhibits A through Y are admitted. Tony, do you have a copy of those? I have not seen them, so if you could forward them to me, that'd be great.
I haven't, I didn't look, Judge. What day did you send them?
Tony, I actually presented a binder for the judge, and I also left it at the desk for your clerk.
Oh, you said you sent it to the court reporter.
Oh, no, I left it for the court reporter on Tuesday when we were there, Your Honor.
Okay. All right. Let's go ahead and proceed. Call your first witness, Mr. Yates.
Thank you. At this time, I would call Robin Hunter.
Ms. Hunter, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. You may proceed.
Thank you. Ms. Hunter, I'm going to ask you a lot of questions, a lot of which you mentioned in your opening statement. But just to clarify, what you and I said in opening statements is not considered evidence. So it may seem redundant, but I need to get this, in the record so that it is in fact evidence.
Okay.
How were you related to Ollie Mae Allen?
I'm her niece.
Okay. And did you know her all of your life until she passed away?
Yes, sir.
And can you tell the court when she passed away?
October 6, 2018.
Okay. And she was a resident of what county as of the date of her death?
Dallas County.
Okay. And the property that's the subject of this dispute is located in Dallas County as well. Is that correct?
Yes.
When did you become aware that Miss Allen had passed away?
The day of.
And you've indicated that you believe that she left a valid last will and testament. Is that correct?
Yes.
And Judge, I'm not sure the best way to pull up exhibits, if you want me to share my screen or if you want me to ask the clerk.
You can share the screen, or I can share the screen for your exhibits, whatever you prefer.
I'll share the screen. That way I can bounce around a little easier.
Okay.
Okay, Ms. Hunter, do you see what has been previously admitted and marked as Exhibit 4? Does that appear to be the last will and testament of Ollie Mae Allen?
Yes.
And it bears her signature and is also witnessed. Is that correct?
Yes.
And then it has what we would call a self-proven affidavit attached to it. Is that correct?
Yes. I mean, I don't know what a self-proven affidavit is.
Okay. And under this will, you are not named as a beneficiary. Is that correct?
That is correct.
Okay. But the will.
What date was this will done?
Does it appear that the date on there is March 30th, 2015? Is that correct, Ms. Hunter?
That's correct.
Okay. And the will does name you to serve as the independent executor. Is that correct?
Yes.
And then Kazina Hunter as the alternate. Is that correct?
Kazina Hunter.
Kazina, is that correct?
That's correct.
When did you first become aware that she may have prepared this will and executed it?
Prior to her death.
Okay.
I knew she had a will.
You knew she had a will?
Mm-hmm.
Did she ever discuss with you the will?
Yes, she did.
What? When was the first time that she discussed that with you?
I'm not certain of the date.
You indicated it was obviously prior to her death. Do you recall about how long prior to her death?
I'm not certain. It could have been a year, 2.
Okay. Did you ever see the will prior to her death?
No.
Did you know that you were named as the executor in that will?
She stated that I would be.
Okay. And you filed an application to ask the court to admit that will to probate and appoint you as the independent executor. Is that correct?
Yes.
To date, the court has not taken any action on that application to confirm whether or not it's a valid will or to appoint you or any other person as the representative of the estate. Is that correct?
Yes.
Is there any reason why that hasn't been done today or by today?
Yes. Because the only thing she has is a home that has been fraudulently taken.
So, but you've asserted causes of action as the personal representative of the estate. Is that correct?
Well, when this lawsuit was filed originally by the plaintiff, that's what was stated.
But you've asserted claims and claimed that you are the personal representative of the estate. Is that correct?
I'm a personal representative of my aunt.
But the court hasn't appointed you as such. Is that correct?
The court has not appointed me as executor of the estate of Ollie Allen.
Okay. And I'm going to show you what's been previously admitted as Plaintiff's Exhibit 3 and it's an affidavit of facts concerning the identity of heirs. Is this the document that you had prepared and filed in the real property records of Dallas County?
Yes.
Do you know what an heir is?
Tell me.
I'm asking you if you know what an heir is.
Oh, yes.
Can you tell the court your understanding of what an heir is in the state of Texas?
The beneficiaries that are due for it's the beneficiaries to the will.
Okay, so in your mind, an heir is the same thing as a beneficiary?
Yes,
Okay. And this document, you claim that the following were the heirs of decedent: Helen Hunter, Helen Hunter, correct?
that's correct.
Dorothy Robinson, correct?
Yes,
Kenneth Paul Washington, correct?
yes,
LaMarcus Harris, correct?
correct.
So Saria Lewis, is that correct?
Soraya,
Soraya Lewis, correct?
correct.
You can help me with this next name.
Nashavia Lewis,
Nachavia Lewis, correct?
yes,
Casey Montgomery, is that correct?
yes,
Marquise Glover, correct?
yes,
And Micaiah Glover, is that correct?
yes,
And so all of those people are named as beneficiaries in that will that you've sought to have probated, is that correct?
yes,
Including Kenneth Paul Washington, is that correct?
yes,
And you don't dispute the fact that Kenneth Paul Washington was the only child of Ollie Mae Hunter, Ollie Mae Allen, is that correct?
I do not dispute that.
And she never had any other children born to or adopted by her that you're aware of, is that correct?
Not to my knowledge.
Do you believe that you had a close enough relationship with her that if she would have had any other children born or adopted by her, that you would have been aware of it?
That is correct. I was very close.
And to the best of your knowledge, she was not married as of the date of her death, is that correct?
That is correct.
Okay. And so her only living heir would have been her son, Kenneth Washington, is that correct?
No. I'm sticking to the heirs or the ones that are stated there.
Okay. I'm going to flip over to Plaintiff's Exhibit 9. And this is under the Texas Estates Code, Section 22.015, the definition of an heir. And here, under the laws of Texas, it states that an heir means a person who is entitled under the statutes of descent and distribution to a part of the estate of a decedent who dies intestate. The term includes the decedent's surviving spouse. So do you know what intestate means?
Yes, I do.
It means
She
without a will.
she died with a valid written will.
Okay. So she died testate, in your opinion, is that correct?
No, she died with a valid written will.
Right. But I'm asking you, do you understand the word intestate to mean without a will?
Yes, she died with a valid written will.
I understand that that's what you're saying. I'm just trying to clarify if you understand that an heir is a term that's only used to define people who would inherit in the absence of a will when they died intestate without a will. But you're claiming she died with a will. Is that correct?
A valid written will.
Okay. And so under this definition, the beneficiaries wouldn't be considered heirs just because they're beneficiaries, correct?
I don't know if that's what you're making claim, but
Mr. Yates, we're not here to test Ms. Hunter's legal knowledge, so let's move along here.
I understand. So you indicated that you were aware that she had a will. When's the first time that you saw that will?
the first time I saw that will was 2019. It was a year later when we read the will.
Who had possession of the will from the date of death until you received it?
Her sister, Dorothy Robinson.
And did you know what was in the will prior to seeing it?
Just only from what my Aunt Ollie told me.
Okay. Did you have any conversations with Dorothy Robinson about the contents of the will after Miss Allen's passing?
No, I didn't need to.
How did you become aware that Miss Robinson had the will?
Because my Aunt Dorothy Robinson is the keeper of all things.
Okay. And when did she let you know that she had the will?
I don't recall. It's just a rule of thumb that she had it.
Was it around March of 2019 whenever you got that will?
I believe so, but I'm not certain.
Okay. And what action did you take at that time to have the will submitted to probate?
Well, the only action I took was to go down to Dallas County to see what is it that I have to do to even probate a will, because I've never had to do that.
And when did you do that?
That had to be the beginning of the year of 2019. I'm not certain.
Was it soon after you got the will?
No, because actually I went to figure out what I need to do to probate a will before I even got it.
Okay.
Because I knew what my aunt had. It was only a house.
And so it's your testimony that you received the will in the early part of 2019. Is that correct?
I can't say for certain that was the date. I
You
cannot say
indicated-
for certain.
You indicated that there was a reading of the will. Is that correct?
That is correct.
Do you recall when that took place?
Yes, it took place 1 year after my aunt's death. And so that was October the 6th, 2019. And it was, yes, it was on a Sunday.
Okay. And you had the original will at that point, correct?
Yes,
At that point, the sale of the property to Mr. Barton hadn't occurred. Is that correct?
that is correct.
So the estate still owned that property. Is that correct?
That is correct.
Why didn't you take action at that time to initiate a probate?
The reason why I didn't is because in the state of Texas, in order to probate a will, you have to have an attorney. In order to have an attorney, you have to have money. The state did not have any money, and each attorney wanted $5,000.
And so at some point you initiated probate proceedings. Is that correct?
That is correct.
And do you recall when that was?
It was, no, I don't recall.
Tell you what, I will pull up plaintiff's
Okay.
exhibit 6.
That
And
would
does
be
this appear to
perfect.
be the application for probate of will and issuance of letters testamentary that you filed in the probate court?
Yes,
And I don't see a date on it. Oh, it looks like it's file stamped August 13th, 2020. Is that correct?
if that's what the file stamp says.
And then I'll also pull up this is the docket sheet for the probate case. Is that correct? Does that appear to be what that is?
Yes,
And here states that the application was filed on August 13th, 2020. Is that correct?
yep, that's correct. That's
So
what the date says.
you have no reason to disagree that that's whenever you started that process. Is that correct, as far as filing it with the court?
Yes,
And do you recall when the sale of the property to Mr. Barton occurred?
it was June 2020.
And I've pulled up plaintiff's exhibit 1.
Can we stop for a second? I'm sorry. Who is Connie Jones?
She is,
She's a defendant, Your Honor.
yes.
Kenneth and Connie.
Is she aligned with you, Ms. Hunter?
Your Honor, to be honest, she's aligned with me, but she is not aligned with me. They're the culprits behind all of this.
She received a share of the proceeds from the sale of the property.
So is Connie Jones here right now?
That I don't know.
Okay, apparently there was, Ms. Hunter, you raised this issue. There was some misunderstanding, I guess. Our court, even though we told you that it was going to be Thursday, there was some misunderstanding and there was a letter sent out. Ms. Jones has just emailed and said that she's not available today and thought that the trial was on the 26th.
Don't give her no out, Your Honor. Tell her she needs to log in.
Okay, let's see what let me see. Rhonda, are you on the line?
And I will say, we attempted to mediate this case. We went back and forth quite a while, but we got it scheduled, and it was rescheduled to a Friday. And Mr. Washington and Ms. Favors failed to sign the paperwork that was required by the mediator and didn't show up for mediation. So we weren't even able to mediate. So this is kind of seems par for the course.
Let me do this. Let me call my coordinator and let's